of action that was pled was breach. I'm sorry. Thank you. That's okay. That's better. Breach of a purported contract. There is no such cause of action recognized in Florida or anywhere that I could find. And what it does effectively, and did effectively in the trial court, was create a contractual issue which is more likely to lend itself to a summary judgment than to an issue of conversion or theft of money or wrongful taking of money, which in fact is what this case was about, which is a fact-based scenario which does not lend itself to summary judgment. As this court knows, review here is de novo because it was a matter of law that was decided in the trial court, and we have a couple of points to make. The first one being that a judgment for a cause of action that doesn't exist should not be allowed to stand, nor should it be allowed to be ratified by this court.
Could that count have been amended had you filed a motion to dismiss?
I did file a motion to dismiss, and it was denied.
And you're appealing the denial of the motion to dismiss or the granting of the summary judgment?
Well, in effect,
or technically the rehearing.
Yeah, well, technically, all of them, because the motion to dismiss was denied, and then we incorporated that into the affirmative defenses after the denial that there was no cause of action.
Do we have a transcript of the rehearing?
I don't believe there was a transcript of the rehearing. I think the rehearing may have been denied even without a hearing. I'm not certain. There was some problem with the dates and the rendition of the judgment, and the case went back, and it may have been denied out of hand, but I can't say for sure. But in any case, there is no transcript. The record below does show that there was an affidavit by the plaintiff in the case, which essentially said that the defendant, the appellant, wrongfully took money. And there was no counter affidavit filed at the time of the motion for summary judgment. Instead, what was relied on at that time and again in this appeal are several factors. The first one would be that there was a response of record to a request for admissions that denied the key elements of the claim.
Do you believe you can use a denial of a request for admission as substantive evidence? Aren't you normally required to do your own interrogatories to prove an assertion that you contend to be correct?
You are, if you get to that point, and certainly if you get into a trial, you can ask questions and then impeach. If you can develop evidence,
so you believe the burden was never shifted?
I don't think right, and that was argued. That's exactly correct.
So then you never had to even file an affidavit, albeit 3 months late. Then.
Well, that's what I thought at the time, and didn't, and you know, that's probably, we wouldn't be here had I filed one, and that's my mistake. But I don't think that I had to. I mean, I guess it's an ounce of prevention argument.
I mean, getting down to the chase, ultimately, looks like your client took $225,000 that there wasn't any contract or any basis for him to take. What's the defense?
There were a number of defenses raised, including that he did have permission to take it, which again kicks it back into a fact question. So yeah, there's no dispute that he took the money. The question is whether.
Where'd the permission come from?
Well, he says it was verbal. It's a he said, she said. It's a classic he said, she said, and I think I go back to that's why this was framed as a breach of contract, a breach of oral contract or purported oral contract, and so there's a dispute as to whether or not he was entitled to take the money.
I don't understand. Why would she authorize him to take $225,000 for basically doing nothing?
Based on the, well, it was not for doing nothing, Your Honor. It was based on the record before the court. He was a lifetime employee of a sort of a very either a solely owned corporation or you know, privately held corporation. He was a lifetime employee, and it was some sort of end of life bonus based on what's before you.
As a fiduciary, I mean, she couldn't just say, okay, take $225,000 because you've been a lifetime employee and a good guy, and
Well,
If she had fiduciary duties, she couldn't just give the corporation's money away, could she?
well, she at the time of the taking, I believe she was a guardian. The principal was
Guardian of the person.
of the person. He was still alive at
Your
the time.
client was the guardian of the property.
Of the property. That's correct. And he says that he got permission to take the money
From the guardian of the person, or her as a
both of them.
owner of the corporation?
That he ran it by her first as a guardian of the person. He was a guardian of the property.
Well, as guardian of the person, she would have been unauthorized.
Okay, that may be. I think they were operating under the assumption that this was a family business. These were not lawyers we're dealing with, and I think this was more of an agreement between the daughter of the principal who brought this lawsuit several years after the death.
Is she the only beneficiary of the estate?
I don't know. I believe there's a brother involved as well, who was a beneficiary of the estate, which leads to one of the other points that I wanted to make this morning, and that is that, and it's while it's not substantive evidence, when you get into resolving all doubts against the moving party, it's curious that it's circumstantial, but this is in essence a theft case that's brought several years after the alleged theft took place. And it doesn't stand to reason that if somebody has money stolen from them and knows about it, that they wait several years to bring a cause of action, and that's something we've.
Well, was there a statute of limitations defense pleaded?
Well, no, it was within the statute of limitations. It simply was addressed an equitable argument that we raised in the defenses, but there's no statute of limitations problem here. So it's within the statute, but it's one of those when you talk about resolving all doubts, it's one of those things that raises a doubt, as does the answer for request for admissions. But going back to
It's not a criminal case when you say all doubt. I mean,
Oh, no.
let's just look at your client's affidavit, which the court rejected, didn't consider, it was 3 months late.
Right.
But there's nothing in there about your argument that he was a lifetime employee and the money could have been given for that person. There's some doubt. I mean, you're throwing that out there today. The affidavit simply says both the plaintiff, and this is very vague, and even if the court considered this, I think they could see a problem with it. Both the plaintiff and I had discussions with an attorney regarding this issue, and it was well known to the plaintiff how the money was to be paid to me and that it was paid. I mean, that's about as vague as I've seen. It sounds like I got the money, I didn't do anything, and I'm not paying it back. That's what it sounds like. Because I had permission to get the money, I don't have to do anything. That's what that looks like to me. And all the other allegations are also vague. I'm over 21, this is my name, I'm the defendant. It was paid, the money was paid with permission. I don't see anything in there that the court could have hung its hat on as being competent evidence to rebut the plaintiff's evidence to the contrary, including the attorney's evidence where Schwann admitted getting the money.
If she has standing to bring the action, as she does, and if she gave him permission to take the money, if they discussed it and she gave him permission, then I think that gives rise to a question of fact. In other words, she can't be out of it on one hand, I don't think, and then
There was a contract that was prepared and sent, and apparently never signed and sent back, and then the work that was called for under the contract apparently was, no one claims that it was done.
That's correct. There's an unexecuted contract, so that is really a nullity. What happened, what the circumstances were, what was done or not done to warrant the taking of the money is an unanswered question. And again,
Well, I mean, if there's permission, perhaps there might have been permission if the contract had been signed, and the work done, but it wasn't.
But that assumes a set of facts that this contract was the only way that Mr. Schwann would be entitled to the money.
Well, what's the set of facts in the record that would authorize taking the money and keeping it that we have before us?
It's not so much the set of facts in the record that authorize it, but the lack of proof that he took it without authority at the summary judgment stage. He's raised defenses. He's answered requests for admissions. There's an affidavit that was filed, albeit late, and rejected. There's
He's not being.
I'm sorry?
He's not being prosecuted in a criminal court for theft.
No, he's not.
He could claim, I had taken the money with permission, but he's being asked for a return of money because he was supposed to do stuff for 7 years. He didn't do anything.
Well,
except he got the records apparently transported to a storage facility.
well, whether he did something or not is not clear on the record. There was a contract, or not a contract. There was a document that was never executed.
The business was supposed to be wound down and put out of business, and apparently that never happened. It's still it was a going concern, at least as of through this lawsuit
Yes.
process.
Yes, that's correct. That's correct. But I mean, the mere fact I'm speculating as to whether or not this or that set of facts could exist, I would argue creates enough of a doubt, because it certainly doesn't rule out the slightest doubt, which makes it resolved in favor of moving.
What is the set of facts that is created by his affidavit or otherwise in the record that would have constituted a defense to taking and keeping this money?
That the appellant and Ms. Diamond, who were the two people who had any control over the person and property of the decedent, who was then incompetent, agreed that he could take it, or they disagreed. I mean, but that's a fact issue. In other words, he says, I talked to her. He says, I was allowed to take the money. Nobody said I couldn't. After he takes it, sometime after he takes it,
It's only a fact issue if you consider the affidavit.
I beg your pardon?
It's only a fact issue if you consider the late filed affidavit.
I don't believe so, Your Honor, because
you think a denial is substantive evidence.
I think a denial of request for admissions under 1.510 in this case is because I think I go back to the fact that this is not a viable cause of action. I mean, if it was a conversion, if it was an unjust enrichment, there's a plethora of things that they could have been pled, but they've pled this breach of purported oral contract, which is not a cause of action. So I don't know how you defend something that isn't a claim.
I know, but realistically speaking, denial of request for admissions, that's not used for purposes of defining and limiting the issues it's not used to gather evidence. It's used to define and limit the issues at trial, and you're using it for evidentiary value. And I keep coming back to that. The case law doesn't allow you to use a denial for evidentiary value. You can define a limit for trial purposes, but this case got derailed prior to trial.
It did get derailed prior to trial, but I think it raises a doubt, or it should have raised a doubt. If you look at the totality of the circumstances of this case, it's about a wrongful taking of money, and the question is it wrongful or isn't it? And
I don't think you told me. How much time did you want to reserve for
a couple of minutes, not much.
Pardon me?
A couple of minutes. I don't think
okay,
I'm going to need.
I'll save you a couple of minutes.
But basically, no, taken any of these things taken alone, the motion to dismiss, the affirmative defenses, and we discussed this a little bit in the brief. The courts have moved away from, just taking affirmative defenses on their face and taking, the boilerplate affirmative defenses, but the ones raised here, are significant enough, taken in totality in the totality of the rest of the circumstances, that I don't believe that the moving party in a summary judgment met its burden of proof, and that's why we're saying the summary judgment shouldn't stand. This case turns on facts. Should he have taken the money, or shouldn't he? And if he shouldn't, if he took it wrongfully, that would be borne out by a trier of fact. If he was entitled to it, that would be borne out by a trier of fact. Thank you.
All right. Thank you.
Good morning, Your Honor. My name is Hamden Baskin. I'm a lawyer from Clearwater representing Linda Diamond in all her capacities. Would like to address Judge Volante's it's not argument, but statement that the denial on a request for admission is not evidence, and it is not. The rule, however, does indicate that an admission, if given, is conclusive of the issue and may be used to help establish facts. So it does limit the issues. Denials are simply going to give us a way to frame these things better and know what to drill into at trial. So what is a breach of purported oral agreement? My client and George, she's here, Linda Diamond, and George Schwan, look, this was a family business for a long time. We specifically did not bring, in this count, a case for fraud, civil theft. Those things may have well been out there, but this wanted to be resolved. So there was clearly, and it's clearly in the record, and it's been admitted by both parties, that there was a discussion whereby $225,000 would be paid to Mr. Schwan for a 7-year run as a contractor, independent contractor, to manage these files. I guess from what I understand, these are the type of files you have to maintain in case customers out there need to come back and get stuff. I don't have a great handle on it, but that's...
I think talking about the IRS 7-year requirement.
It could well be, but there were warranty issues in there and things like that. So we needed to manage the files for 7 years. So how are you going to do that? So this was the idea. So Merrick Gardner, an attorney here in Tampa who had done the business law, was asked to prepare an independent contractor agreement.
Well, do you think it would be easier to just recite the legal issue rather than the factual? I mean, we've read the file, we're familiar with the facts. Was the summary judgment proper here?
It was, Your Honor. The summary judgment was proper.
And supporting the summary judgment?
It is, and of course the court is aware that in coming into a summary judgment, if the plaintiff is going to move forward and prove her cause of action with summary judgment evidence, she must do so at the summary judgment and must get that evidence pointed to. There's a memorandum of law, point out the summary judgment evidence, and in doing so we had the affidavit from Merrick, affidavit from with exhibits, affidavit from Linda Diamond. We had the complaint. We had the defenses that were raised by George Schwan. Now, I believe it's clear that we proved up the elements to the cause of action. There's really no doubt in my mind, either by admissions or most of them by admissions, but otherwise by the affidavits from Merrick Gardner and Linda Diamond. And so once that happens, then it is incumbent on the defendant to come forward and show that there is still a disputed issue of fact. And that is the problem that we have. There's no memorandum of law pointing Judge St. Arnold to any evidence in the record by the defendant to say there is a disputed issue of fact, because it does shift once the elements are proved, and that's what we did.
Beyond that, there's no transcript.
No, sir, there is no transcript of either the hearing on summary judgment.
We don't know what was argued.
No, only the written page, Your Honor, is all we can go on, and the order itself, which is fairly meticulously drafted, coming forward with what was provided. But in order to preserve a record for appeal, it seems to me that it would be incumbent on the defendant to at least file a memorandum to be able to show record evidence for this court's review. Frankly, this is what I pointed out, but it's devoid, and there's nothing there. We filed a memorandum in support as well as the supporting affidavits. Now, this thing was filed back in December. Actually, October 30th, I believe, was the motion. And then in December, we set it for hearing for January. January came on the 8th. The arguments were held, and the court ruled, I believe, on the 22nd. And I do agree, at that point, we were doing the electronic service, but the order came out. But even if you would want to consider the out-of-time affidavit, it doesn't have any substantive disputes in there that would be sufficient.
Well, when are you required to file the affidavit under the rule?
Well, he would have had the affidavit in more than 2 days prior to the hearing.
He was 3 months late.
He was 3 months late, and not only that.
So the court abused its discretion in not considering the affidavit?
The court did not abuse its discretion, Your Honor, and we recited numerous cases in the brief on that point.
Was a factual basis even argued as to why the affidavit wasn't filed for so long?
It was not. And if you notice in the record on appeal, there is no copy of the motion for rehearing, to my knowledge. It is not on the record. Now, I put a copy in an index, but really it was not made a part of the record on appeal, but it is in my index, and if you look at it, there isn't anything referenced in there. There are no defenses really referenced in that motion for hearing, and certainly nothing about a cause of action or anything like that. But here's the other concern. I issued a motion for order requiring factual information sheet to be filled out by the defendant, and that went over to the defendant, Your Honor, on April 18th, and it was still the 30th of April before a motion was even filed to try to set aside the summary judgment. So to me, when you come in and you find out some adverse entry of an order has happened, you have to act with all dispatch. Is it 1 day, 2 days? It's the discretion of the court. But this court, this judge, St. Arnold, had no abuse of discretion in denying to look at an affidavit that was 5 months after I filed the motion and 3 months, I believe, or at least 2 months after the motion for summary judgment. I think if you make the argument you want to get an out-of-time affidavit in, you try to make it at the hearing. And certainly not, if not at the hearing, you do it the next day. But this court has lots of case precedent affirming the fact that a late filing is not something that has to be considered by the court, maybe except for the most exigent circumstances. So once we came forward with sufficient summary judgment evidence, then the burden shifted over, and now they are relying on a denial that was set forth in the request to admit, which we've established will not serve as a basis to find a material issue of fact. So we don't have that. So what do we have left? Well, now for the first time, I'm hearing that this money might have been a life bonus, or none of that is in the record. There is nothing in the affirmative defenses that would indicate that this was anything except an agreement that was made. I will pay you $2 1/4 for 7 years. We've got to get a written contract to do it. Now you'll see Exhibit 4 to Merrick Gardner's affidavit, I think, is critical, and it's the middle paragraph. And he's reciting his conversation that he had with Merrick Gardner back in earlier that year when he took the money, and it says, George told me he was taking the money, taking the check, and was signing the agreement. That's Merrick Gardner saying that. And so Linda Diamond probably did say, if you sign the agreement, you're the guy that signs checks, go ahead and take it. But then you also look at the detailed handwritten note that George Schwann wrote to Doug Williamson. Now, Doug Williamson is a Clearwater attorney that handled the probate side, and he probably reused the day, but he kind of had dual representation of Linda Diamond and George Schwann in their rolled up bundle of rights as guardian. But nonetheless, this letter that was sent and admitted as authentic by Mr. Schwann was sent to Doug Williamson, and it says, I have taken $225 on an agreement to manage all this for 7 years. And so we know that there was at least traction on this agreement. Nobody's disputing that. The issue was it supposed to be pursuant to a written contract? Well, you've got overwhelming evidence that it was, and you have nothing in the record from George Schwann that would indicate otherwise. It was up to him to come forward with a sworn affidavit on a timely fashion to create this factual issue that we could try at court. That wasn't done, and Judge St. Arnold carefully reviewed the record. I think he had it under advisement for a couple of weeks, and then the order came out. So I think Judge St. Arnold, it should be affirmed. I think the summary judgment has its use in our jurisprudence in cases like this. Had it been denied on the basis of affidavits coming in, we would have known exactly where to drill. Where is this case going to go? But after a year and a half, the defendant had done nothing. And at that point, a trial judge can assume, literally, at least I think in his own mind, that they've gone as far as they're going to go. They didn't ask for a continuance. They didn't say, Judge, I want to take advantage of the rule that says I want to conduct more discovery prior to this hearing. That wasn't done. And so hence, they simply rely, as far as I can tell, on the notion that we didn't plead a cause of action. And I think you'll see that in this complaint, we incorporated by reference paragraphs 13 through 18. And in those paragraphs, it outlines the requirement for the memorandum, a written agreement for independent contractor, and all those are imported into count 1. So, yes, it could have been pled as a theft. It's not where we wanted to go. Simply wanted the money back. The deal didn't go down. He took the money. He had no right to keep it. And so to come in and say, well, we had this nebulous oral agreement, but it can't really be an oral agreement because it would be violative of the statute of frauds. So this is what happened. Return the money. He didn't do it, so we filed. And so I think, Your Honor, we do state a cause of action. I think they put nothing up in return. I think we proved each and every element that we made. And I would ask this court to affirm Judge St. Arnold below.
Thank you. All right, Mr. McGowan, you wanted 2 more minutes, you said?
Yeah, very briefly. Just a couple of points. I don't think there's any issue here whether or not the trial court abused its discretion doing or not doing anything. The issue is that this summary judgment needs to be reviewed de novo. Here, Judge St. Arnold was well within his discretion not to accept the affidavit, and we never argued anything to the contrary. Mr. Baskin just said that that a verbal contract, to enforce a verbal contract to take the money, would be violative of the statute of frauds, and yet, excuse me, yet he's traveling on a violation of or a breach of a purported oral contract, which goes back to the argument that there is no such thing. You can't prevail on a cause of action that's not recognized by the courts as a matter of law. And saying we could have pled theft, we could have pled conversion, well, they didn't. And they pled breach of a verbal contract.
They did plead unjust enrichment, correct?
They did. They didn't. They pled some kind of an equitable claim, but they did not plead an unjust enrichment, which they could have pled.
All right.
And the last point is, when counsel talks about, as defendants, we sat on it for a year and a half and did nothing. It's not the defendant's burden to move a case forward. It's the plaintiff's burden, and they can't complain that we didn't do anything during that time. Thank you very much.
All right. Thank you, gentlemen. Have a good day.
Here you are.
Thank you.
We're going to move right on to the next case. That would be Tuck versus State.